Hi, I'm Nicole Sloy, the Operations Director here at Qdos Contractor. In today's video, I'm going to be speaking to you about IR35 reform. In this session, what we'll cover off is what the reform is coming into play 6th of April 2021 now, what challenges organisations might face, both client and agency side, as well as some more specific questions on some areas that organisations want to get into the detail of, especially in advance of the introduction of the legislation in a few weeks' time, and also for them to incorporate that into their planning and preparation activities that they are undertaking now. One of the questions that I'm asked quite frequently is that will the introduction of the off-payroll legislation into the private sector end contracting? And I think that the short answer in our view is that it won't. So that's not to say that the introduction of the legislation hasn't presented a lot of challenges. It's not to say that the legislation hasn't to date seen a potential reduction in the number of contractors delivering their services by limited companies. And it's not to say that it hasn't caused a significant amount of disruption up until the point where it was delayed in 2020, so last March, right the way through to as organisations begin to prepare. But despite all of these challenges, I definitely don't see it as being the end of contracting. And that's for a number of reasons. If we look at the wider kind of economic landscape in the UK at the minute, when we think about the extended ramifications financially of the COVID-19 pandemic, contractors are going to continue to be absolutely essential to the economy's recovery. So organisations who have gone through extensive furloughing schemes, organisations who have perhaps gone through extensive restructuring of their organisation, contractors in contingent labour models are typically the first to be removed when organisations are looking at a restructure. But equally, as part of a recovery, organisations then identify where they have a requirement for key projects, and actually bringing in temporary contingent labour is the best way to do that because it is a very specific project. They need a specific skill set. So I think as we come out of the COVID-19 pandemic and the UK's recovery as part of that, the utilisation of contractors is going to continue to be absolutely imperative to that. So whilst we may see some peaks and troughs over the utilisation of contractors in the run-up to April 2021, also just thereafter where we go over that kind of tipping point of the introduction of the legislation, I think we will see that start to come a bit more balanced as we go through the rest of 2021. So for us, the contracting industry is very much alive. We're just going through a period of significant change, both when we think about IR35 and off-payroll reform, but also given the implications that COVID-19 has also had on the market as well generally. HMRC designed and launched CEST back in 2017 ahead of the introduction of the public sector off-payroll reform. It was intended to be used as a tool to help organisations consider the status of their contractors. And from day one, when the system was first launched, right through to where we're at now, it has continued to come under a significant amount of scrutiny. HMRC themselves have, from their perspective, gone to great lengths to improve CEST, to better it. It has gone through a couple of iterations in its life cycle, but I think it's important for organisations to really think about the challenges that are still prevalent within CEST, even where we're at today. So firstly, if we think about the fact that it is a digital tool, so it's algorithm based, there is a limitation on the fact that it's algorithm based. So questions are multiple choice or yes or no only. So we don't have the opportunity to look at some of the more specific details that we definitely want to when we're typically trying to consider status. In addition to that, that limitation actually means that in some scenarios, the HMRC assessment tool can in fact spit out or return an indeterminate result. So it won't always give organisations an answer. What that can actually mean is it maybe pushes some organisations to then try and game the system, go back through the assessment process a couple of times, because surely an answer is better than no answer. And that presents a whole host of other compliance, not taking reasonable care type risks. And it's not necessarily organisations' fault that they're being presented with a guidance tool from HMRC that actually doesn't give them a full range of outcomes that they actually should be expecting from an assessment type facility. In addition to that, when it comes to IR35 status, The basis upon which we consider status is all reflective of case law and the key status tests that are derived from case law. Now, the 3 key status tests when it comes to IR35 are substitution, control, and mutuality of obligation. Now, HMRC's CESS tests assumes automatically that mutuality of obligation exists, and this goes directly against case law. So already at the point of making an assessment and utilising CESS, you're potentially on the back foot from there being already negative information already being considered before you've actually even answered one single question. In addition to that, we've also had some examples in tribunal cases over the last year and couple of months where judges have classified the CESS determination as irrelevant. We've had some scenarios where we've actually had HMRC trying to remove a CESS determination from evidence as part of a first-tier tax tribunal. So we can see actually in the tribunal cases where we get to find out the outcomes of these challenges with IR35, judges actually not considering CESS to be a legitimate means of making an assessment. In fact, there was one particular case where it was referred to as simply being a tick box exercise. So these are other aspects that organisations really need to think about if they're going to be using CESS. And the message certainly from Qdos is that you shouldn't be using CESS as a result of that. It leaves organisations too exposed. You're not really taking reasonable care if you're already assuming that mutuality of obligation is present within an engagement, because that goes against case law. And the fact that you're not always going to get an answer when you use CESS as well. So all of these things coupled together present a whole host of issues with the platform that were prevalent at the outset, that remain prevalent today, that should really prevent organisations looking at this as their only means of making IR35 determinations. If you are a contractor and you're watching this, for you the changes to the IR35 legislation and the off-payroll reform are actually quite significant. So going forward, when you're providing services as of the 6th of April, where you're working for a medium or large company or a public sector entity, then you in fact will no longer be responsible for considering your IR35 status. That responsibility is going to sit squarely with the organisations who in fact engage you. Now, as a contractor, that can be quite a difficult situation because you're used to having the opportunity to feed into and contribute to and actually participate in how your status is actually considered. So there are a few things that contractors can do to assist with that and have the opportunity to feed into a process. We always suggest that contractors look at previous status assessments they've had undertaken themselves. So it's possible that you will have, for the current contract that you're working on, because today it's still your responsibility, have had your IR35 status considered by an industry expert or had a form of review done. Look at that and see if that information is actually valid to what your engagement is today and what your engagement is potentially going to be come post 6th of April if you're still going to be with that client. And use that as a mechanism to inform discussions with your clients when you're chatting about your status. And that's another big thing. Proactive communication with both your client and your recruitment agency is also recommended. Now, if you haven't yet had your status considered, you've had no communication from your client, again, an option would be to approach both the parties in the supply chain, so agency and client, to find out exactly what their plan and their approach is going to be with IR35. In addition to that, you might also want to, aside from having your status independently assessed, look at other ways in which you can collate evidence around how you're actually potentially operating outside of IR35 genuinely. So for example, can you demonstrate where you have engaged helpers? Do you have a scenario where in fact you have actually provided a substitute? And a whole host of other things like that, because it's important when having discussions with your clients that you have information to back up the statements that you're making in respect of your status. It's also entirely possible as well that the client that you're working with may engage the services of the likes of a Qdos or another provider like us, where you might actually be asked to participate in an assessment as well. So it's important when you're going through those processes that you give an accurate depiction of your working practices, and where possible, and where perhaps you think your determination has been incorrectly made and that the client has come to the incorrect conclusion, you will always have that mechanism and right to make a challenge against a determination that is made in respect of your engagement as well. So you can exercise your rights that are available there as another means of communicating and engaging with your client when you're having those conversations about status or having been in receipt of an SDS that you think is actually incorrect. The work that Qdos has been doing in both the public sector space and the private sector space over the last 4.5 years now has been specifically around helping organisations through the implementation phase of the legislation. So that's through our consultancy and advisory services via our IR35 based audits, as well as presenting organisations with a means by which to make individual case-by-case determinations and issue SDSs, both per your requirements in advance of the legislation, so thinking about the current population, as well as what a business as usual process looks like. So now that mechanism that we designed for undertaking those case-by-case assessments is a facility called Status Review. Now, since its implementation in 2017, Status Review has supported over 2,200 organisations, public and private sector, in making individual case-by-case determinations, in making role assessments to assist with recruitment, and also managing disputes as part of that client-led disputes process. The assessment facility itself takes into account both technology, so we give you access to an online platform to manage the administration of your assessment process, whilst also, and more importantly, utilising our in-house expertise via our IR35 consultancy teams, whereby it's individual IR35 consultants that actually make the determination. So you're getting best of both worlds with man and machine. In addition to that, access to the platform itself also gives you the ability to track the progress of your assessments. So you can see with a click of a button how many contractors you have progressing through the assessments project and what the outcomes are. Now, there's a whole host of additional functionality that's been designed within the system that can help make it an even more useful tool, such as providing read-only access to other parties in the supply chain, the help and support section on the platform that both hiring managers can utilise when signing off determinations or that contractors can utilise when they're going through the process. And the fact that the assessment facility involves you as the client, you as an agency if you're there in an administrative capacity, and the contractor in that assessment process bodes well to demonstrate all of the requirements under the legislation, so issuing the SDS, having hiring managers validate and sign off the determinations based upon their knowledge and their view of the working practices, the fact that the SDS is issued to relevant parties in the supply chain, the fact that we have the built-in disputes process, maps both what's required legislatively, but also helps with introducing an efficient and fair process that benefits the contractors because they get to participate in the process, benefits the client and the agency where you're confident that a compliant IR35 determination has been undertaken, with the addition of the Qdos tax liability policy that sits behind the assessment facility, offering organisations that extra peace of mind and comfort that should the worst case scenario arise and HMRC actually undertake an investigation and find that you have made an incorrect classification of workers, that tax liability provision is there to protect you in the event of that, both covering the liabilities that could in fact be due, but also covering the representation costs that are required to see you through that inquiry phase as well. In the description box below, you will see that there is a link to a free guide. The guide covers off in great detail all the specifics around the reform that we've covered off in today's video. You can also subscribe to our videos to make sure that you stay up to date with future updates from Qdos. As always, if you ever have any questions, please don't hesitate to get in touch with Qdos. Leave a comment in the comments box and also make sure that you subscribe in order to get access to any future videos that we publish on the subject of IR35 and all other contracting matters.